Presiding Officer, Sandie Peggie, an NHS nurse for 30 years, spoke up for her sex-based rights in her workplace because she did not want to share a changing facility with a biological male. But in doing so, she's been treated as the perpetrator, not the victim. I know that the presiding officer considers this case to be sub judice. Nothing I say here today will prejudice any live proceedings, because at the heart of this case are the policies of the SNP government. Presiding officer, we need a ministerial statement on public sector workers and single-sex spaces. I am grateful to the Minister, despite the late notice, for being open to considering this request. Yes.
Jackie Baillie.
Can I thank Tess White for taking the intervention? The protection of single-sex spaces based on biological sex is a matter of law. It's in the Equality Act. In supporting the motion for a statement, would Tess White agree with me that the Scottish Government and its agencies are not above the law?
Tess White.
Thank you, Jackie Baillie. I completely agree with you that the Scottish Government and its agencies are not above the law. The situation that has arisen in NHS Fife speaks volumes about what is happening behind closed doors in Scotland's public sector under this SNP government. The reality is that Nicola Sturgeon's self-ID policy has binned the rights of biologically female employees to access single-sex spaces. Taxpayers' money is being used to cover legal costs to defend a public body's gender policy. But there is no transparency over the cost to the public purse because the health board involved will not disclose this information. Presiding officer, that's simply not acceptable, especially when the health service is in crisis and budgets are being squeezed. It's been reported that the Health Secretary, Neil Gray, was made aware in June last year of the situation in NHS Fife and the legal implications surrounding it. Presiding officer, we need clarity over Neil Gray's involvement or lack thereof. And presiding officer, the public interest in this issue is huge. It has been covered extensively in the press. MSPs have been contacted by constituents with legitimate questions and concerns, and yet we haven't been able to bring these questions to the Chamber. Topical questions, FMQs and urgent questions on this issue have not been selected. Meanwhile, our colleagues in Westminster have been able to raise it. It is deeply disappointing that once again this Parliament cannot discharge its duties to the public because members do not have parliamentary privilege. Presiding officer, women are watching today. The public have had enough of the recent abdication, obfuscation and moral cowardice from this government. We are only going to see more witch hunts at the public's expense if we do not get clarity on the Scottish Government's position. And I urge members to support my amendment to today's business motion. Thank you.
Thank you, Ms White. I call on Jamie Hepburn to respond on behalf of the Parliamentary Bureau. Up to 5 minutes, Minister.
Thank you very much, President Officer. Let me set out why we cannot accept the request for a statement and cannot agree to the amendment in Tess White's name. First of all, she has very clearly indicated the rationale for bringing forward this amendment as her disappointment, and I do not know whether it was in her name or another colleague's name, that an urgent question was not selected for answer today. Of course, that is your prerogative, President Officer, and not the Scottish Government's, where any questions put to the Scottish Government that you have selected, of course, will come to this chamber to answer it. In relation to the request for a statement, there are three reasons particularly I do not think that we can accept it today. First of all is the schedule that we have before us. It is already a busy schedule. This Government is always open to ensuring that we are rightly held to account by this chamber. That's the very reason I stood up my feet to move an amendment to business just a few moments ago. There was a request by the Conservatives for a statement on the future of Grangemouth. I propose that we schedule that today. The Bureau has agreed that. There was a request from the Labour Party that we schedule a statement on the promise. I agreed that. It was agreed at Bureau. I propose that we schedule that for tomorrow. There is a debate being added on a legislative consent motion for Great British Energy. I had suggested that only required to be moved and then voted on because there had already been an LCM taken. There was a suggestion that there could be interest in having a wider debate on that issue. I've acceded to that. So this government is not afraid of being held to account by the Chamber, but I'm afraid to say, in terms of what we already added to our parliamentary schedule this week, does not allow us to accommodate another statement. The second issue, and I don't think any of us would suggest that any individual here, the government, any administration is above the law, but we do need to be conscious of the law. And notwithstanding Ms White feeling that she's navigated safely staying the right side of sub judice, there is, I believe, an inherent danger, because we heard quite clearly the rationale for the request for this statement relating specifically to an individual employment tribunal. There is a danger that we could stray into that territory, and I don't think any of us would want to step across that ongoing process and put it at jeopardy. That would not be fair to any party taking part in that process. Of course, I give way to Mr Fraser.
Fraser.
I'm grateful to the Minister for giving way. I can entirely understand the Government's reluctance to comment on a live criminal case, particularly a criminal case involving a jury which might be swayed by comments made in Parliament. This is not a criminal case. This is a civil case being determined by a very experienced employment specialist judge. There is no barrier, there is no risk of prejudice from a minister in this government speaking on the broader issue of access to single-sex rights, other than cowardice.
Well, there speaks the voice of inexperience, because, of course, sub judice doesn't just relate to criminal cases, it, of course, relates to civil cases as well. So that's a nonsense from Mr Fraser, absolute nonsense from him. It's a live case, and there's going to be a tribunal. We need to be careful what we'll say, and I'll say no more in relation to that matter. The last point, no, I'm afraid I will not give way to hear from Mr Kerr. We hear from him all too frequently, so we won't hear from him on this occasion. The last point, and I think this is also an important point to make, Presiding Officer, is that this request wasn't made at the 11th hour, it was made at beyond the 11th hour. It's not good enough to come at the last minute to ask the government to make a statement the same day. Frankly, it isn't acceptable to ask that of ministers, but it's also not fair on Parliament. To schedule a statement the same day does not give Parliament the courtesy of having lead-in time to ask questions. That law over there might have known of the plan, no one else did. That's not fair. I urge Parliament to reject the amendment.
Thank you, and I would remind all members of the need to treat one another with courtesy and respect. The question is that Amendment 16518.1 in the name of Tess White, which seeks to amend Motion 16518 in the name of Jamie Hepburn on behalf of the Parliamentary Bureau on changes to the business programme, be agreed. Are we all agreed? Yes. The Parliament is not agreed, therefore we'll be moving to a vote, but there will be a 5-minute suspension to allow members to access the digital voting system. The result of the vote on amendment number 16518.1 in the name of Tess White is yes 47, no 64. There were no abstentions. The amendment is therefore not agreed. Point of order, Douglas Ross.
Thank you, Presiding Officer. Parliament has just decided, we assume with the votes of SNP and Green members, not to allow a statement on this crucial issue. Parliament has just decided that. Well,
let us hear Mr Ross.
SNP
Do continue.
members seem to think this is funny. I actually think this is serious. for Parliament to be able to address an issue that is both topical and urgent. And I use those words, Presiding Officer, because topical questions, urgent questions and First Minister's questions have been submitted to you, of which none were selected. And I know it is frowned upon for members to challenge the ruling of the Chair, but given the decision that Parliament has just taken that the Government will not allow a statement on this issue, and you as Presiding Officer will not select questions on this issue, when can the Scottish Parliament and members of this Parliament debate this important issue? And can you also advise that there is an opportunity for Parliament to sit longer tonight? Because the SNP Minister, in refusing this statement from the Conservatives, one of the three reasons he gave was because Parliament is already sitting until 5:15 tonight. Is it really the decision of this Parliament that we can't sit until 6 o'clock, perhaps, to debate this issue and to get a response from ministers? And on the point of sub judice, could you also give advice on that? Because the question that I submitted on this issue this week, as both a topical and a First Minister's question, was to get advice and guidance for all NHS boards across Scotland, not just NHS Fife. And surely it is not right for constituents of all of these health boards to have to wait until potentially after July for this employment tribunal to reconvene before they get the answers from government ministers in this Parliament.
Thank you. I would say that in line with long-standing convention and in common with my predecessors, I do not give reasons for selection decisions. I consider each question lodged carefully and in line with published criteria. There are many important questions submitted each week. I do not expect challenges to my authority where a member is not selected on a specific item of business, and as Mr Ross pointed out, members have opportunities throughout the week to raise this issue. Mr Ross, I will ask you to stop speaking from your seat in that manner. You are an experienced member of this Parliament, and I am sure you are wholly aware of the opportunities that are available to you. Further to that point of order, Mr Ross, I have nothing else to add, so please do not repeat what you have said previously.
To my previous point of order, Presiding Officer, you offered opportunities throughout this week for members to raise those questions. Could you advise what those opportunities are? Because you've refused them all.
Mr Ross, I have explained the situation quite clearly. I am not sitting here explaining matters that you understand wholly thoroughly. You are very well aware of the opportunities that exist to all members to raise this issue, and that is the case this week, as with any other. Stephen, point of order, Mr Kerr.
Presiding Officer, in connection with Rule 13, 13.4, 13.6b and Rule 5.4, can I ask you, Presiding Officer, for your guidance in relation to a significant matter of public interest which is now being reported out with this Parliament, and that is the reason that's being given, or floated, I would suggest, as to the reason why the issue that Tess White raised and Douglas Ross has raised is not being discussed in this Parliament this week as per the business papers, and that is that the issue concerned is described as sub judice. But in fact, would you agree, Presiding Officer, that employment tribunals in Scotland are not subject to sub judice, and therefore would you care to clear the matter up, because the media speculation may be misrepresenting what is happening inside this Parliament? And I think it's very important that people of Scotland know, because this is a big issue outside of this Parliament as well as inside the Parliament. The people of Scotland need to know, I think, that this is not the reason specifically, because it's not a matter that is sub judice.
Mr Kerr, I can confirm that I have not ruled that this matter is sub judice. We will now continue with our item of business. The next question is that motion 16518, in the name of Jamie Hepburn, on behalf of the Parliamentary Bureau, on changes to the business programme, be agreed. Are we all agreed? The motion is therefore agreed. We'll move on to the next item of business.